First thing we are going for co-owners. Co-owners is all the joint owners who are registered as a patent proprietor or grantee or patentee. Now, the rights with them, the 50 talks about the rights and 51 talks about the dispute of the between the co-owners if any arises. Okay. So the first thing is these are the few points which you should remember, and these are various co-owners. Co-owners has all the joint owners have equal undivided share in the patent. Okay. Here equal is if there are two, it will be 50-50%. If there are three, it will be 33%, 33.33, whatever it is. If there are so 25%. But the share is undivided. What is undivided share? Undivided share is, suppose, let's understand with a physical property. What happens in a physical property? Suppose you have inherited a property from your parents, and you have uh, your parents had 4 children. Then each children will have equal share in it. But the day it has been given to you, or land which you have received, though you have equal share in it, but where do you have that equal share? North, east, west, south, there is nothing, no limitation has been given to you. No boundary has been crafted. So each and every particle of that land is owned by jointly by each shareholder in that land. Since this is called undivided share. Divided share means that I can differentiate, I can create a boundary and then go for it. That's why you would have heard that partition has happened. And in partition, you decide that one brother is taking north, another brother is taking south, third brother is going for a east direction, and fourth brother is going for the west direction. So regarding that, and equally, had it been a 200, suppose it was 10,000 square feet area, then it is 2,500 square feet divided in each person's shares. But here, patent cannot be divided like that. So you will always have an equal undivided share because there cannot be a partition. That's all. Then comes each co-owner is entitled to all rights of patent because whatever the patent is happening, you will enjoy all the rights of patent without accounting for other persons. So everyone have the equal rights and all the rights. Equal in the sense 25%, 25%, but all the rights. What are the rights associated with patent? Come to give that to prevent anyone using the patent without his consent for making, using, selling, offer for sale, and importing. That's what it is. That's what all rights will be there. Now, a co-owner cannot assign its share or license the patent to any other person without consent. That means if you are transferring your share or licensing, in this case, unanimous consent should be raised. See, simple thing, please understand. No one can, since you are enjoying all the right, so other three also cannot assign it without your consent. So if any assignment is happening or any licensing is happening, everyone should agree. Then comes if suppose patented article. What is a patented article? Patented article is simple, a product which has been manufactured by a which itself is a patented product or which has been manufactured by the process of patent. If that is done, if you have sold that product, that patented article, purchaser shall be entitled to deal with this article as if sold by, as if it's sold by sole owner. So the understanding is if anyone is purchasing, he is said by your drama. You got the money, whether this money will be distributed even down, he is not bothered. You have given him the product. He is a bona fide purchaser. He is not worried whether the money has been shared by you among the co-owners or not. He will be entitled to deal as if you were the sole owner. Third part says that patents or all the patents which the ownership and devolution related rights will be as good as the laws of movable property. They will be governed by the laws of movable property. That means patent is considered a movable property. What is a movable property? Movable property is like bike, pen, pencil, book, all those are movable property. While when we are talking about immovable property, anything which is fixed in general is a immovable property. For example, house, land, trees, those are all immovable property. If you cut the tree, obviously the wood is movable property, but before that, rooted trees are immovable property. So now that this is how this is. So all this is if you are transferring it, the movable property laws will be applicable. Now comes our rights of assignee of partial interest in patent created before commencement. So they are saying the rights of assignee of partial interest in a patent created before commencement of this act will not be affected. This was a protective provision. It's not needed now because after 1970, 20 years have passed way back. So there is no patent which is surviving or whose assignees will be here at least. So this is not that relevant. Now comes to 51. If there is a dispute, how that will happen? See, if co-owner is there, the co-owner can co-owners subject to direction, sale or lease of subject of direction. Co-owners can approach controller for the direction first. And what is the subject matter of direction? If there is a dispute related to sale or lease of a patent or any interest therein, or grant of a license, or any exercise of right under section 50. Then under section, whatever the right of patent they have, if there is a problem there, they can always ask, let's see what direction we have a dispute, let's go to controller and get it resolved. So controller, you can approach the controller, owners can, any owner. So there are a co-owner, for example, there is ABCD and A is not satisfied, A wants some directions, then he will go for, he can approach the controller. He is approaching controller under form 11. He will find a statement of fact and who can approach? Two or more co-owner can approach. So A plus B has to approach. Okay, now they have come. Now controller sends. Now controller says the controller sends a copy of application. Controller has received the application. Now he will send the application statement. This copy, whatever he has received, a copy of that will be sent to other co-owners. So all other co-owners will what happened is these co-owner is what? They can be registered grantee or proprietors. Now they have received it. Now if they want to oppose this, whatever the request has been made, they will oppose. And as we have discussed earlier, the provision notice of application will notice will be sent to applicant, and then they will get a time to respond of 2 months, and later on, after their response, the applicant himself can reply, and then if hearing is required, the hearing will happen, and then controller can give the direction. Here the controller give limited direction. One, he can ask you to do anything as required to fulfill or not, and to execute any instrument or not. The controller will say, okay, go for this agreement or this execute an agreement or go for this sale or lease in this format. If that is not happening, if controller has given you a direction and 14 days have passed and the person whom the direction was given is not complying with, okay, then the other registered person, either of the registered person can approach the application of controller that, and again form 11 will be filed, statement of fact will be given that this is how we have approached you, you have given the direction, but the same direction is not being complied with. Then controller will send the copy to the person who is in default, who is not following this particular his directions. Then Again, entire opposition format will have come and the proceedings will happen. After proceeding, controller can give you direction. What direction can be given? That they can empower any other person to execute that interest, that instrument on that person's behalf who is defaulting, or do things on behalf of the person who is the default. Same thing, right? He is not following, someone else can do that. And now this will be as per the law because it will be done under controller direction. Now, what direction cannot do? What direction cannot do? The controller cannot give a direction which can affect the mutual rights, obligation of trustees or legal representatives of deceased person or their right. Okay. They can also not give a direction which is inconsistent with the terms of the agreement between the registered grantee and proprietor of the patent. If there is existent agreement, he cannot override that. Okay. One thing I will again emphasize is entire understanding 1, 2, 3, 4 is subject to unless agreed otherwise. Co-owners can agree among themselves that one person will be holding 10%, other will be 20%, 30%, 40%. They can do that. So if there is an agreement for that effect, that will be followed. So this is the entire co-owners concept. Now the second concept. Second concept comes assignment. If you got a patent, how can you assign and what should be done? Assignment and transfer. Transfer can be how many kinds of transfer you have, There is, see, you can sell. This is one transfer. Another is you give your patent as a security and get money. That is called mortgage. You can mortgage it. You can license it and get the license fee. There can be any other, for example, there can be, you are going for part of the patent, you are saying part of the patent or whole of the patent means you have only given the right to manufacture the product, not sell. You have said you manufacture and you give it to me, I will sell. Or you are giving manufacturing right to someone else and selling right to someone else. That can also happen. So depending on this, that how you are using, there can be an assignment in whole or share of patent, a mortgage, a license, or the creation of any other interest in the patent shall be in writing. Whatever you are doing, it should be in writing. Oral will not be applicable. Oral agreement is not going to happen here. Then comes, and all the T&C should be properly covered and it should be duly executed. When I say duly executed, what does that mean? Duly executed means it has a proper stamping and everyone who is interested in this has signed it. That is duly executed. And if this is a company or anything, then their seal, if required, it should be sealed and it should be executed by their authorized signatory. That's right. So anyone who is signing it should have the right to sign and it should be executed on a stamp paper of correct way. That's how it is. Now comes assignee, licensor, mortgagee, person gaining right. If it's not licensor, actually licensee. Assignee, licensee, mortgagee, person, anyone who is getting the right, irrespective of whether under agreement or transmission or operation of law, or he should apply in writing in Form 16 to the controller. So the person who is gaining the right is applying in the Form 16 to controller for registration of his title or notice of his interest in the register. Now, if request, and you can always say that since license is commercial, right? So there will be various commercial terms. You can always say that my license terms should not be disclosed, keep it confidential, and those will be made, those can be kept confidential unless they are under the order of a court by the patentee or license. Okay. Now, application for the registration of title or notice of interest of any person. Simple, when you are approaching, you have to give the proof. Without that, controller cannot enter. The proof of title or interest has to be provided. I believe there was a confusion between title and interest. I have messaged it. Title is the ownership. Interest is anything less than the ownership. For example, a licensee has an interest, mortgagee will get an interest. If you default, he has the right to acquire. This is the interest you have created for it. While entitled, you are the owner, you are the proprietor. You have all the right to exercise all the rights which you have. Okay. If there is any dispute, suppose there is a dispute, if there is your assignment, mortgage, license, or whatever transaction is there is disputed, controller can refuse to take an action, and uh, he will not make an entry in register unless a court order has concluded your dispute. So when a patent is in dispute or anything is in dispute, it is not any assignment is in dispute. Sorry, any assignment or any transaction related to patents in dispute, the entry in register cannot be made. Now comes document not registered, noted in register. Why we are doing it? Why you are going and telling anyway you have an agreement? Why are you going to register? The only thing is, if you don't register it, if you don't get your transaction noted in court, it will not be used as an evidence. So this is the reason that you register it, you note it. Okay. Now, what is the exception of this law? That unregistered and unnoted document is relevant and can be used in evidence is when you are applying for registration of right, title, or interest in the register of patent. Then the document is non-registered. You are only telling it, you have executed it. So there, that is one exception. Another is, suppose you have this document and you want the register of patent to be rectified and you have approached the High Court. Then this unregistered document will be taken as an evidence by High Court. Otherwise, in any other proceeding, it will not be taken as an evidence of type. Now, for example, what is that kind of this? For example, you got it assigned to yourself, but you didn't register. Someone infringed the patent. Now, in infringement, if you go with an unregistered document, court will not recognize it as an evidence because they say it should be registered and it is not falling under the two exception which has been provided. So court will not recognize it as an evidence. Before admitting it as the evidence, you have to get the register of it rectified. Then only they can take that as an evidence. Now, every assignment and every other document. So what it is saying, any document which is transferring, if you are submitting 2 copy of assignment or the document certified to be true copy by the applicant or his agent must be submitted. And if controller thinks that there is a need of another proof of title or written consent, he can ask for and you have to see. This is with respect to assignments. Now we are going for restoration of lapse patent. Can you tell me when patent lapse? What are the circumstances when patent is lapsed? Patent lapses.
Sir, if the renewal fees has not been paid.
Correct. So when the renewal fees is not been paid. So the renewal fee is not paid. So simple thing is restoration of lapse patent, where we studied it 60 and 60 to 62 deals with the restoration of lapse patents. What happens is that under section 53, you are supposed to pay the renewal fee within a prescribed period. What is the prescribed period? That before the expiry of the statutory time limit, that is plus 6 months if it is extended. So we say that you should pay it before the commencement of the new in the commencement of the new financial year, you should pay the fee. Now, if you have not paid the renewal fee, suppose you have not paid the renewal fee, the date on which that was the last date on which the renewal fee was supposed to be not paid, from that date. After that date, it will cease to have effect. That date is very important. It will consider a date of cessation. From that date of cessation to 18 months, you have a right that you can apply for restoration. So if you apply for restoration, then that means this is like this on 1/1/2021. It says to have effect. Then you have 18 months to apply. Suppose you applied on 1/12/20. Okay, I'm applying for the restoration. So who can apply? Patentee or assignee, their legal representative, one or more applicant with leave of control. So these people can apply who have an interest. Actually, the patentee, assignee, or legal representatives can of these patentee and assignees can apply for the restoration of the patent. And application for restoration will be under 15. In form 15, what you have to do, as you are doing in everything, first you will tell big objective. What is the objective here is that your patent should be registered. So you have to tell what happened that you could not pay the renewal fee. So you have to give a statement in which you will tell what were the circumstances which led to the failure of the renewal fee, and you will provide the evidence that because of these circumstances I could not pay the renewal fee. What you have to establish is that you have to establish that the failure to pay was unintentional and no undue delay in application for restoration, and you are not lethargic in coming to the controller to get it restored. There has been no undue delay. After that, once it is done, then further controller can ask for more evidence if he is not satisfied by the evidence you have submitted. Then first thing is, if controller is prima facie satisfied, he will publish this thing that an application for restoration has been filed for this application. The restoration application will be published, and it will be open for 2 months for any interested person to oppose this patent. How? Suppose this was the when controller is prima facie satisfied. If he is not satisfied, what he will do? He will give you a notice. He will again give a notice to the patentee and and he will ask within 1 month you can request for hearing, and in hearing you can try to convince the controller. If he gets convinced here, this is incorrect, restored, it should be this. It will again go to the publication because he is now satisfied. Otherwise, he will refuse, and your revocation will not work. If he is convinced, then it will be published in the official and this line will be followed. Now, within 2 months, if anyone is interested in your patent, he will file under Form 40 and oppose it. So again, remember the entire procedure of opposition will follow here. That he will give you a notice. You have the right to respond, and then he will give a further evidence. And if there is another evidence required, it can be filed with the leave of the controller, and then hearing will be scheduled. And after the hearing, something controller can decide. Now, when Form 14 is being filed by an opponent, what he has to say, what you are trying to prove, he will prove otherwise. You are trying to prove that there is failure to pay is unintentional. He will say that failure to pay is intentional. Then say no undue delay in application. He will say there is an undue delay in making application, and he will submit his statement. And since it is a requirement that he should be an interested party, so he will tell what interest he has, the grounds why he is coming to you, and all the facts he will state, submit the evidence if required, and go for the opposition. Controller will give the notice to applicant, and the opposition proceedings will happen. and later on it can be disposed in the favor of applicant. Suppose it is disposed in the favor of applicant, then restoration order will be given. If it is not disposed in favor of applicant, the patent will stay lapsed, and that's it. Here the restoration, suppose he gave you a restoration order, then in 1 month, only in 1 month, you have to pay the unpaid renewal fee and any additional fee. Then once you have paid it, then restoration will be published in official journal and restoration order. What restoration order is? There can be, in restoration order, controller can write these terms. What is the terms? That, see, the moment patent stops to have effect, anyone can start using that patent. Now that person has done no wrong. He has started using your patent because you never had the right. His use of invention should be protected and compensated if required. So provision and condition to protect and compensate the person using invention during the period of cessation. One terms, and no suit. You cannot go for an infringement between when you were in your entire rights were in cessation. Since you never had the right, your rights were in a suspended mode, you cannot file a suit for infringement for the activities done during that period. So this is how the restoration of last patent happened. Okay. Now we are talking about revocation. Revocation is what? That you will be deprived of all the patent which has been given to you. All the rights will be taken away. So how can you do it and what are the grounds should it be? Remember, pre-grant is before, pre-grant opposition is before the patent is granted. After the grant, only 1 year you have within which you can approach and get the and you can ask for the and it can be revoked. It is under the post-grant opposition, but revocation under section 64 is very different. Revocation under section 64 can be in different forums. So there are 3 points, 3 forums where revocation can happen. One is a High Court, second is central government can directly revoke, and third is the controller can revoke. When we are discussing this revocation, we are not discussing the revocation under the post-grant opposition. We are discussing it out of it. Okay. Now, section 64. Section 64 talks about that any person interested or a central government who can be a petitioner, who can approach court or controller, who can be the applicant who is asking for the revocation of the patent. An interested person can be there. This central government can be an applicant. Counterclaim in suit of infringement of patent. See, this is very important. If there is a suit of infringement, revocation can be claimed. Your patent, you never had a right. The patent, this is the best defense. If you can prove that the person who is asking for the infringement and the compensation never had the right, then yes, you don't have to pay any compensation. There is no infringement if there was no right. So revocation is also used in the infringement procedure. Revocation can always be in the High Court. Now comes the grounds of revocation. These are the grounds of revocation. As we have discussed earlier, everything which Acts prescribes and has not been followed is the ground of revocation. For example, it starts with claimed in Indian patent having earlier priority date. Third, it has prior claiming. The patentee is not entitled to, Then C is that the patentee has wrongfully obtained the patent. D is subject is not an invention as per section 3. it relaxed novelty. That is, it is publicly known or publicly used in India before the priority date or published in India or world. Now, please remember, when we are discussing the novelty, our idea was the novelty is global, whether it is published or used, right? That's how we were proceeding. However, if I'm talking of revocation, use is not global. Use is in only in India. For revocation, use in India and before the priority date are published in India or world. The publication is global, but use is restricted in the territory of India. This is the difference. Now comes import of product or product made by the method constitute knowledge or use, whatever. So this is import is also import will be also considered as lacking because of use is because of import. Okay, so what are the exceptions? Uh, Section 1 talks about the ground, Section 2 talks about the infection, then subsection 2, then subsection 3 also talks about the exceptions. So I have taken those exceptions and put here only, just for your better understanding. And I have reduced the I have summarized the title, the entire para which has been given there as few words, just for your convenience so that you can remember it faster and write that. You cannot remember the entire para and write it there. So now comes personal document, secret trial use, and import for reasonable trial or experiment is exception. Then inventive step, publicly known or publicly used in India before the priority due. This use will take away the inventive step, or publication will take away the publication will also take away the inventive step. Import will also use it. However, same exception will follow personal documents, secret trial or use, import of reasonable trial or experiment. Now comes not useful invention. If, see, invention, inventive step, and then non-useful invention, that there is no utility of the invention. Then comes claim related requirement, not sufficiently and fairly disclosed, base method not described. Second, scope of claim not sufficiently and clearly defined, not fairly based on the matter disclosed in the specification, right? Then comes, it is based on the false suggestion or false representation. Whatever has been represented there during the course of proceedings is they have made false suggestion and representation. That is also a ground. If the subject of claim is not patentable, that is, now we are coming to the section 4. Section 4 is atomic energy. It deals with atomic energy. It was not patentable. Done. Then come secretly used in India before priority date. Secret use in India before priority date is also an exception. Okay, it can also be a ground. Now, what is the exception is 3. Reasonable trial or experiment, for that you have secretly used, communicated, disclosed to government, government undertaking or authorized person of government by applicant, yes, and disclosure by any person without consent, acquiescence of applicant. If these 3 are, except these 3, if it has been secretly used before priority date, then yes, it can be considered as the that it can be revoked. Now comes non-compliance of Section 8 disclosure. If you have not complied with the Section 35 secrecy direction or Section 39 foreign filing license, leave to amend the patent was obtained by fraud, then yes, you have amended the patent and the amendment was obtained by the leave which you have obtained was by committing a fraud. Non-disclosure or wrongful mention of the source of geographical origin of the biological material and anticipated by traditional knowledge of any indigenous community anywhere in life. So all this is the ground of revocation. Now comes how revocation happens by different authorities. High Court can revoke under Section 64. Controller revokes under 65 and 85. Central government revokes under 66. 66. So remember 64, 65 and 66. 64 for High Court, 65 for Controller, 66 for Central Government. 65 plus 20, 85, that it goes into the domain of compulsory licensing. So 85 is with respect to non-working. If it is not being getting work, then 85 comes. Otherwise, this is in on different grounds. First, let's talk about High Court. In High Court, you can, any interested person or central government can file a petition, or under counterclaim in a suit for infringement, revocation can happen. Central government can directly approach the High Court under 64(4) and ask for the revocation. Now the grounds are, when central government can get anytime. There is nothing prescribed. While everywhere else it is prescribed anytime after grant of the patent, that anyway it will be, because before that it cannot be revoked. But counterclaim in suit for infringement 64(1) will be necessary. Now, the ground is what? Under 64(1), all the grounds which we have discussed at present, just now, those will be the grounds. However, in 64(4) is that government has asked, said, asked for, requested the patent to be used for government use, but and has offered reasonable terms under section 99, and without any reasonable cause, patentee has not complied with the request. Patentee is not giving his patent to government for use. Then government will say, government will approach High Court and say, revoke his patent. The patentee in person registered as having title and interest in the patent will be notified. They will have a right to defend, and High Court will listen to both parties and decide accordingly. Similarly, if it is a dispute between the person interested, or central government has asked for the after the grant under 64(1) on the basis of grounds which we have discussed earlier, then also again the interested the patentee and the person registered who have the title or interest in the patent will be notified, heard, and it will be decided. This is the procedure in High Court. What happens under 66? 66, central government. Here central government is very clear. If your patent or exercise of patent is mischievous to state, okay, government thinks that you are, whatever you are doing is prejudicial to general public, or it is derogatory to the state, or mischievous to state, then yes, central government will give you a notice. Central government will directly give you a notice. You will have a right to defend yourself, and after hearing you, they will revoke. They will give a notice for revocation. However, in controller, what happens when controller is needed? Controller is needed that when under 65, if invention is related to atomic energy. If invention is related to atomic energy, central government got notified notice of it. Central government cannot directly revoke now. Their ground of is very simple. Central government can directly revoke only if it is prejudicial to the public or mischievous to state. These are the only two grounds under central government can directly revoke. Otherwise, central government, if you are denying central government the government use, and when the reasonable terms were offered to you, then central government has to approach High Court and get the get your patent revoked. Central government can also get it revoked on the grounds under 64(1) by filing a petition to High Court. But under atomic energy, they have to direct the controller. On the receipt of that direction, controller will give you a notice. Okay, patentee and the patentee person registered who has a title and interest, they will give you a notice. Once the notice is given, you will be heard, and they will allow you to amend the specification so that it can be, your invention can be taken away from this restriction. It should be taken away of the atomic energy. If that is possible, you can amend and save your invention. Otherwise, no. It will be revoked. Now comes 85. Under 85, Form 19 has to be filed. And who will file? Interested person or central government. Central government again comes. Okay. Okay. Ground is here now that post grant of compulsory license, the license is the non-working of the patent is still not being worked. That means not worked in Indian territory, reasonable requirement of public is not met, or the public at reasonable affordable price, it's not met. The patentee and other person, interested person as per register of patent, and decision will be within 1 year. This I will discuss tomorrow again in detail. Okay. So please consider 85 not discussed. I will discuss it again while discussing the compulsory licensing and how and what grounds you will remember. Now comes the procedure. Let's go to the flow chart. Okay. So, revocation of the patent. Who can file the revocation of patent? We have discussed person interested, petition of central government, counterclaim and suit for infringement of the patent. Who can, under High Court, what will happen? Grounds we have discussed. 64.1, exception 64.2, 64.3. Now, on this comes direction. By direction, on direction. We have discussed all this. Okay. Now, format is what? Under 64, you have approached the High Court. A petition will be filed by person interested or government. Or in a counterclaim, you can go, you have to find the grounds and then it will be done. Under section 99, non-compliance, again, central government have to make a petition to High Court and you can get it. Under section 65, atomic energy problem, we have discussed the direction, controller, notice to patentee, and this hearing will happen and then revoke will happen. 66, central government himself give you opportunity to declare in the official gazette, patent will be deemed revoked. Done. So this is how revocation is happening. 85 we will discuss tomorrow. Now comes the two things which we have to discuss. One is surrender of patents, another is the amendment of patent granted to deceased applicant, ceased or body corporate that ceased to exist. Let's go for deceased applicant. Under section 64, it says that there can be a situation where the applicant dies. There is one where he dies during the proceeding, right? The proceeding were happening, applicant dies, then you have a right to substitute under 20. That we have discussed, section 20, that assignment, death, transmission or operation by all those will happen there. Now, in section 44 is that the patent, when on the day patent was granted, before that, applicant had died, but patent office didn't know. They were not informed. So what will happen is, or a body corporate ceased to exist just before the grant of patent, and there is no information with respect to that to this. This is the general scenario. So what will happen before the grant of patent, since applicant and died, so anyone who has died cannot own anything, right? So this is a general concept. Similarly, if a company was found, so it cannot be owned by them. Our company was merged. Company does not exist more anymore. Someone else is there. So what will happen is you can the application in Form 10 will be submitted by the person, surviving members of the applicant who have died, or the company who has ceased to exist, in that who is inheriting the rights, who has got, for example, if it is wound up, shareholder will get it. If it is merged, new company will get it. So depending on that, that person will apply in Form 10. Form 10, they will give substantiating evidence that I am the one who should, that the other person has ceased to exist, he has died, or the body corporate ceased to exist. Now, these are the evidence, the wound up certificate you have got, or the death certificate along with the uh, probation certificate, whatever you have. You are a legal heir of it or legal representative of it. That evidence, if you can submit with along with your application, the controller will amend the grant and substitute the name of deceased for the name of person whom patent ought to have been granted. This will now it will be deemed that a patent was always granted to you. You were the grantee. It will always to have had effect from the day one because patent cannot any property cannot be without owner. There should always be some owner, right? So that's why it is deemed that the patent was always owned by the person who has been substituted under section 44. So this is the section 44. Easy way to remember is 4-4, right? I tell every time that it's easy. You might not find that connection, but try to make some connection here. You will remember for Form 10, a person died and you are 0, he becomes 0. That's why Form 10. There is no right done. You remember like this and you will get it. In Form 20 also you are substituting. In Form 10 also you are substituting. The only thing is 0 in 1 is die in when in 10 he is dead before the grant, while in 20 the death or assignment has happened during the application. Now comes surrender of patents. Section 63. By patentee at any time, patentee, once you have got the patent, you can have all the right to surrender anytime. In any time, you can offer to surrender it. Now, if there are more patentees other than you, or there is a licensee, assignee, whoever is, there will be those people who are registered in the your e-register. Now, offer to surrender you have done, you will submit it to controller. Controller will publish this offer to surrender and at the same time also notify every person registered in the patent register as having who has the interest in the patent, except the patentee because he has filed. So, except that person, everyone will be notified. 3 months will be given. All these person can file a notice of opposition in Form 40. Now, same thing, 14, when you get a notice of opposition, patentee will be notified and proceedings will happen. If it is accepted, revocation order will be issued and published, and thus the patent will be revoked. This is how surrender of patent will happen. Surrender of patent is happening under section 63. Okay. Now, let's go for another concept. Power of controller. Power of controller. This is a very important topic. Most importantly for MCQ and mainly the 3 marker. Okay. For 3 marker, this is one of the most important topic. They can always come here and ask. Now, section 77, what are the powers of civil code? First thing it says that all the power that controller will have the power of civil code. While trying a whatever the civil code has a power while trying a suit under CPC, same power will be held by controller. And what are those matters? See, they can examine anyone on oath. They can ask someone. They can ask someone to attend the proceeding. They can ask someone to appear before them. That is the summoning and enforcing the attendance of any person and examining them on the oath. So this is a court function. Court does that. Second, they can ask for discovery and production of the document. They can also receive evidence on affidavit. They can also issue commissions for examination of witness of the documents. They can also award cost. They can review their own decision on application made within the prescribed time and in prescribed manner. They can set aside any order passed ex parte on the application made within the prescribed time and a prescribed manner, or any other matter which may be prescribed. So this is how the power controller. I will explain each and one thing again. Summoning is asking someone to come, and examining him on oath is that you are going to take an oral evidence. That evidence is what? Let's first understand what is an evidence. Evidence is that someone is saying evidence can be documentary or oral. There cannot be any third type of evidence. Documentary is you submit a document. For example, you have a certificate, you have assignment agreement, all those are evidence which are documentary evidence. They can be hard copy, they can be soft copy, not an issue. There can be email. Email is also an evidence which is in soft copy, while there can be a letter which is in hard copy. So those are the evidence. When I'm talking about evidence, those are the documentary evidence. There can be few things which a person knows, right? And there is no other documentary evidence. He only can come and explain that. Then that means that person is going to give you oral evidence. If we take an oral evidence, we take it on an oath. And when, or you can take evidence from people in affidavit. In affidavit also, you swear upon it that whatever you are telling is correct. So that can be evidence in writing. You give in writing that affidavit you are submitting to them. And along with that, you also give supporting document, whatever you are claiming in the affidavit. That is receiving evidence on affidavit. Discovery and production, that suppose an opponent, there is a problem. You don't have an assignment agreement, right? Assignment agreement itself is with the third party. The other party has never given you the original of assignment agreement. You have only the hard copy, only the copy, photocopy, whatever was given to you. The original needs to be submitted. So they will ask the other party to produce that document because the original is in their hand. So that way, discovery and production of the document can be happening. Discovery and production can again go for example, in you have gone for inventorship, then they can ask for the lab records and other things. Okay, let me see. Were you working there and how? So they can ask for discovery and production of that document also. This is what discovery and production of document is. Commission of examination of witnesses. Witness means you have come and you will examine. Examination, cross-examination, all those is also a court job, but even controller can get it done. Then comes awarding cause. Suppose there are some places where the proceeding which has been done, controller is of the view that it is reasonable that whatever the other party has created a mess and they are required to compensate the first party, then yes, he can award the cost. But there is a limit to which he can award the cost. Schedule 4 talks about it. This is what I'm talking in the awarding cost. See here. It says any order for cost awarded by controller is executable as a decree of civil court. Civil court decree, once done, then execution can be done by a court. You can approach a civil court and ask it to be executed. Similarly, for controller decree also, you can approach a court and court will deem it as good as a decree of civil court and execute it. In all proceeding before the controller, cost may be awarded if he thinks that it is reasonable as per the circumstances of the case. Cap is given in the 4th schedule, not beyond that. And he can also ask for a compensatory cost. If the proceeding which has been initiated by the other party is false or vexatious. Vexatious is just started to trouble the other individual. Okay. Now comes review. What is review? Review is that controller himself will look into his own decision. This is the review power. Review, that is looking again. View is looking at it. RE is again review, revise. That's what it is. Review. Okay. So now review is a simple procedure. It is mentioned in under 77F. So what happens is, if any order of the controller, any order when I'm talking about whether appealable or non-appealable, everything can be reviewed. So an aggrieved party can approach to the controller, and within 1 month of the one order, they have to approach. If in 1 month he is not approaching it, then I will just give you a flow chart of this again to you. This has not been scanned, so I'm not sharing it here. So 1 month of the order or further period as the controller may allow. And this 1 month, it can be extended 1 month at a time. So 1+1, not more than that. So this is the time period in which you can approach for review. Then comes, okay, so time period we understood. What is the form? Under form 24, you can ask for the review from the controller. Okay, rule 130 governs it. And there are the grounds. Grounds are discovery of new important matter if there is evidence not known earlier or could not produced earlier is there, or there is a mistake or error apparent on part of or any other reason, you can always approach for the review. On basis of these grounds, you will give a statement of the ground, and once the application is received, you will also give a copy to the other person concerned, right? If other person is necessary party. Now, then comes, again, same thing will happen. You have asked for the review, and proceeding will happen, and the hearing will happen, and the order will be passed. This is how your review will happen. Second part is setting aside an order passed ex parte. What is ex parte? Any one of you knows that what is ex parte?
Without the presence of other party.
Yes. See, what is happening is that on schedule or a hearing, other party could not attend, and he has a reasonable ground not to attend. Then, if but an order was passed against, so you can ask controller to set aside an order passed ex parte. However, please note, ex parte order doesn't mean that the person who have it was passed without merit. Ex parte simply means the other party was not present. The order is always given on the merit, and the merit is decided on the basis of whatever the material was present in front of the controller. So order passed ex parte is on merit, but you can request for setting aside that order, because there can be few things which you have not mentioned in the document, or all those evidence which has been available to the controller at the time of deciding the or having the hearing. So you can always go for setting aside that because of some reason you could not attend, and that reason was unavoidable. So again, same thing, you have to give him an application in 1 month from the order, and you can get it extended for 1 more month, and same review procedure will be here. All that which I have discussed in review will be followed, and if he finds that your whatever you are saying is fine, he will set aside that order and again go back to the hearing phase and decide accordingly. Okay, so this is the setting aside of an order. Now please remember rule here. All the rules which are talking about this should be remembered. Now 128, direction not otherwise prescribed. Now we are talking about the residuary power of the controller. What is not given anywhere, how controller will handle it. Controller can handle it, and he can, this is how, when, if anything for which he thinks that it is necessary for a party to perform any act, file a document, or produce evidence for which no provision has been made. there is no provision, then he can by notice in writing and require such party to perform the act, file the document, to produce the evidence specified in such notice. So this is a residuary power. That means if he feels that it is required for the proceeding, it is necessary, then he can give a direction to that effect. If someone wants to be heard or not heard, controller can ask him to submit his statement in writing, giving all those information which controller deems necessary. So yes, this is how he can go for his powers, for which nothing has been prescribed. So these are the direction where he can give the direction. Then 129 talks about the discretionary power. Discretionary power is simple. I have a right to do this or that, but this discretion, say, always remember, discretionary means I can do what I want, but it cannot be in arbitrary manner. Arbitrary manner means that there is no reasonable ground for acting in that manner. Controller cannot act in arbitrary. Ki mera man kiya, I did at the whims and fancy. No, there has to be a reasonable ground on which his actions are being made. So first thing is that discretionary power should be exercised with due care and caution and not in arbitrary manner. And all the reasons on basis of which you are going for it should be recorded. When I say all the reasons should be recorded, there is one term you might hear it when you are reading the cases. This is called a speaking order. Any order is considered a speaking order if the grounds on which the reason the order is being made is mentioned in that order, and every order which is there should have the reasons recorded. You cannot pass an order without any reasoning. You have to tell this evidence I've seen, and on basis of this is the reason on basis of which I'm deciding in this manner or that manner, whatever you have decided. Reason should always be there. Now, before acting adverse to any party, suppose you are going to decide something which is going to harm other parties' interest or right, then the other party has a right to get an opportunity to be heard. As I have told earlier also, this is a part of principle of natural justice, Audi alter partem. Audi is here, alter other, partem is party. You have to hear the other party before deciding against it. So that's why opportunity of being heard is given. That's why you have seen that in every opposition, there is a hearing for parties given, and the applicant, both parties are given the opportunity to produce their evidence, and then hearing is scheduled. If any party wants a hearing, they should tell the controller at least 10 days in advance before the expiry of the time limit is specified in respect of that proceeding. This is very much necessary. You must request for your hearing. That's why what happens in every application when a patent agent or anyone files, he always says that if hearing is required, please schedule it. You make a request in the form itself. Okay. Now, then comes, suppose you are going to exercise any discretionary power, then which will affect any other person adversely. That is, first, opportunity of being heard has to be given. And for that, for an hearing, you have to give at least 10 days notice. That is a reasonable period should be given. You cannot say, I've given you an opportunity to come within 5 minutes. This is not an opportunity offered to be opportunity given to be heard. This is not a reasonable period. You cannot ask someone to controller cannot say, okay, come within 2 days. No, this is not a reasonable period. Statute prescribed 10 days notice is a minimum to be given for other party for any hearing. 10 days is because he has to go. If you give some person notice, he has to look into why he has given the notice. He has to prepare the documents. He has to obtain those documents. Then only he can appear for the hearing. So he has given a reasonable time in which he can prepare. He can come and present his case before you. Then comes an applicant for patent, a party to the proceeding, make request for adjournment or hearing with reasonable cause. If you are requesting for an adjournment, then that adjournment should be at least 3 days before the date of hearing. You want a hearing to be adjourned. So please go before at least 3 days. You have requested 1 day before. Then controller is not bound to look into those hearing. So you have to make a request for adjournment at least 3 days before. Then controller, if he thinks the hearing, he can also adjourn the hearing only twice. And once the adjournment is being done, it cannot be for more than 30 days. He cannot adjourn a hearing for 60 days. No. Adjournment shall not be more than 30 days. This is how your discretionary power of controller is being exercised under 129. Then controller has the power to correct the clerical errors. There are 3 parts where we have understood the amendment of application: 57, 59, and section 44. This is how we are saying that where the amendment of application is happening. 57, 59 is the amendment of application. 57 by controller, 59 by the High Court, and 57 and 59, sorry, 58 is not, 58 is for High Court, 57 is under controller, and 59 is governing how the amendment of application can be done. Now, under section 54, we have asked that the amendment is happening because the applicant has died before the grant of patent. So, except this, controller can correct any clerical error in patent or in any specification or the document filed. Now, for this, you have to request him in a writing, and who will request? A person interested, who is suffering because of the clerical error in this, along with the prescribed fee or without such a request. This is how it can be done. Now, then comes controller proposes to make any correction as aforesaid, otherwise than in a pursuit. If suppose controller is taking, there is a with or without request, right? So if controller is proposing to make any such correction as aforesaid, otherwise in pursuance of a request, he will give notice of the proposal to the patentee or applicant for the patent and any other person who is concerned, and give them an opportunity to be heard before making the correction, because this correction might alter their right. Where a request is made, suppose request is made, then controller thinks that this correction will materially alter the scope of the document, then of the document to which request relates and ought not to be made without notice of person affected by, then he will send the notice to the notice will be published in the official journal. Notice of the nature of the proposed correction will be published in the official journal, so that everyone is notified that this is being made and people may be affected. If you are going for a request, then this request should have a copy of document highlighting the correction clearly, plus the prescribed fee. And again, same thing, any person, once it is published, any person interested can give notice to controller of opposition, and if the position is given, the opportunity to be heard will be given to the opponent. Same thing will happen. The procedure specified in 58 to 63, filing of reply statement, leaving evidence, hearing and cause, shall so far as be applicable to the proceeding. This is the rule 58 to 63 relates to the general format, which I have discussed earlier, and that's how it happens. All the opposition proceeding works like that, except one thing is that in previous post-grant opposition board is formed. That is the only different from other opposition proceeding. Only in a post-grant opposition, the opposition board is formed. Otherwise, all the post-grant oppositions work in the same manner. Now, rule 137. Controller may amend any document for which no special provision is made, and any irregularity may be corrected which can be obviated without detriment to interest of any person. See, Please remember these rules. These are very important with respect to MCQ. Then comes rule 138. Controller can extend time prescribed under rules for a period of 1 month. So maximum period which controller is entitled to extend the time is 1 month. Where he is not entitled is this. These are the exceptions. Class 1, sub rule 4, rule 20, sub rule this. Please go and look into this. Which subject matter they are dealing. I'm not telling it, I can tell you, but I want you to go through it so that this exercise helps you in remembering the particular provisions. Just go through it, you will restart remembering. Can anyone check 24P, 24C? Anything, any idea?
Yes, sir. That is for normal 48 months. If year first examination report. No. Yeah. And 24/6 C for expedited examination.
Okay. Oh, nice. Now it's coming to, I'm not sure with the B, but yes, expedited examination. That is correct. Application to grant, that cannot be application to put application in order for grant, that cannot be extended except as prescribed in the section 6 months. That cannot be extended. Yes, that there you are correct. Now comes the offences. This is the old list of offences. Jan Viswas Amendment Act has changed it, but it has not been notified. So it has not come into, sorry, it has been notified, but it's the date from which it will come into effect or force has not been it's not been declared. You can check whether it has come into force or not, but I will be giving the circulating notes on two things. After the completion of all the classes, that will be 1 or 2 pages. One is with respect to Jan Viswas Amendment Act, and second will be with respect to changes in the Biodiversity Act with respect to Patent Act, which can affect the Patent Act. That's the only two things which I will circulate. It will be simpler document. I will not be teaching it. You can read it on your own. But please read those two. Those are the recent amendments, and you might get questions on that. Then comes this 118. See, this exists till now. There is no change. Non-compliance of Section 35 secretarial action or application for patent in control of Section 39 for an application by Indian resident without permission of controller. This is 2 years imprisonment, fine, and it can be both. Now, false entry in any register under patent and making causing, if you cause any false entry in register, it can also go for an imprisonment. False claim of patent right and filing of a patent application, no. Then imprisonment is not there, but fine is there. 1 lakh. Wrongful use of patent office, I think this is deleted. This one is deleted. Wrongful use of word patent office resulting in belief that business patent offices. This is been removed by Jan Viswas Amendment Act, but I will check and get back to you. But before that, please remember the number. Okay. Either way, it will be important because they can ask what has been removed and or what has been inserted. Both can be asked. So please remember this. Then come refusal where to provide requisite information under Section 105. Any information and use of patented invention for government purpose. If you have not provided, Section 146, statement of commercial working patent. If you fail that working patent annual statement, you are not providing under Section 156. There can be 6 months imprisonment, fine, as well as both. This is imprisonment or fine or both. Okay. Then, if you are practicing patent agent without register, then for first 1 lakh, second 5 lakh. Okay. This was the provision before the Jan Viswas Amendment Act. You have to remember this also as well as the revised the difference which has happened. So this is also important because please remember, because that has not come into force. Please check if anyone of you can check that whether any date for that enforcement has been prescribed. The act has been notified, but whether the date for enforcement of that has been prescribed or not. Now comes, if a company is offense, simple, who is in default will be responsible. Any officer in charge of responsible or business deemed guilty. That is, who is an officer in default. Defense is that the offense which has been committed is without his knowledge, or he was he has taken the due diligence, he has taken all the reasonable care. This is the defense. He is guilty if there was a consent, connivance, or negligence. Then the officer who is, because company cannot be in prison, the person who is guilty will be in prison. Now comes scientific advisor and patented. Okay, scientific advisors. Scientific advisors are nothing but experts who are asked by court in who are needed by court in the suit for infringement. There might be need for the subject matter experts. These are the subject matter experts in this area where they are. For that, they are they are appointed to assist the court. They can inquire, report into the question of fact or of opinion, whatever is required, not of the law, but of the science, technical matters. So these are the technical matter experts. So, and they are remunerated by the court as per whatever they fix. Now, what happens is the patent office keeps a roll of scientific advisors and it is updated annually. What is their name, address, specimen signature, photograph, their designation, education qualification, as well as the experience and the discipline of specialization. For example, he's an electrical engineer, he can call on that. If there is someone who is in biotech, who is renowned in biotech, that can be finalized. Can be asked for the biotech invention and they are questioned. What are the qualification which is necessary? First thing is he should be science, engineering or technology grad. Then 15 years of technical, practical or research experience is must. 15 years, please remember this, 15 years. And he should have a responsible post in central or state government or any other organization. He should have a post in central, state or any other organization. Then list is anyway available online. Then comes disqualification. This disqualification is same disqualification will fall for the patent agent also. So please remember, he is unsound mind. Unsound means competent court has decided that he is of unsound mind. He cannot make the reasonable decision. Then he cannot be included in the list of scientific advisor. If he is undischarged insolvent, insolvent means he has no money and other things. So those he is bankrupt. Simple. If he is undischarged insolvent means his debts are more than his liabilities are not discharged properly, so he is not there. If he has been discharged, then say when you are discharged, you should get a court certificate from court that your insolvency was because of misfortune, not because of your mischievousness. Because of your misconduct. So if it is because of misfortune, then a discharge insolvent can be taken as on the roll, otherwise not. Then comes, you have been convicted for some imprisonment. Then, unless you have been pardoned or that disability has been removed by the government, you cannot be on the roll of scientific advisors. Or you are guilty of professional misconduct, you cannot be a scientific advisor. Qualification is simple. When any person interested can apply it at any time to controller for inclusion. If controller is of opinion that there is a reason for that he can relax any qualification, then yes, he can relax and can enter the name of any person if after inquiry he deems. So after inquiry he can give. So these are the places where how you can get registered as a scientific expert advisors. Now, how can you be removed? You make a request, you can be removed. If any error or misrepresentation or suppression of material fact has been done, you will be removed. If you have again become convicted of an offense, guilty of a misconduct or professional capacity, guilty of misconduct in his professional capacity, then yes, you will be removed. This is how scientific advisors. Now, another 5 minutes for patent agent, which you all are going to become. So, patent application can be filed and prosecuted by an applicant and registered Indian patent agent. No one else has the right to file and prosecute the patent application. Eligibility for registration is simple. You should be a citizen of India. You should be of at least of age of 21 years. You should be bachelor degree in science, engineering or technology or any other equivalent qualification. Second, this is the minimum qualification. Then along with that, you should either pass a qualifying examination that is patent exam, or pass minimum 10 years of experience as an examiner or controller, or both. And now you don't hold that post. Then you can also practice as a patent agent. At the same time, you have to pay the requisite fee. If you don't pay the fee, your name is not on the register. You cannot, though you have qualified all this is there, but you have not paid the fee, your name will be removed from the register. You cannot practice as a patent agent. Now, register of patent agent, please remember, you can get again MCQ on that. Register of patent is maintained under section 125. Name, nationality, address, same, everything from which you can identify name, nationality, address, email address, principal place of business, address of branch office, everything is there. So date of registration from where you have done, and renewal of the registration is also there, and any other particulars as a specified controller is in the register of patent. Register of patent agent also contains your specimen signature as well as the photograph. Now, application for register of the patent. How will you do? This is a very important part. Once you qualify, you will fill in the form 22 and submit it to them. And that's how you will apply and furnish other information as may be required. You will ask all the proof that you are a citizen, degree you hold, and you have filed the qualified. You have qualified the examination. Now, this you all have done. A person desirous to appear in qualifying examination under Rule 110. Examination is being conducted under Rule 110. Shall make a request to controller along with the fee specified. This you have already made the request and paid the fee, and now waiting to receive the admit card. Then comes disqualification for registration as patent agent. Same thing which we have discussed there. Adjust by competent court to of unsound mind. You are undischarged solvent. If you are discharged solvent, then you have not obtained the court of certificate that your insolvency was caused by misfortune, not by your misconduct. You have been convicted by competent court for a term of imprisonment, and your conviction has not been pardoned, or the disability has not been removed by the central government. Now, guilty of professional misconduct or guilty of negligence or misconduct. Same thing, but it is applicable to being a legal practitioner or being a chartered accountant. Then rights of patent agent. Rights of patent agent is simple. You can practice without control. You can prepare all documents, transact all businesses, discharge such from other function as may be prescribed in connection with any proceeding before the controller. This is these are your rights. Okay. Subscription and verification. All application and communication control under this act may be signed by a patent agent authorized in writing in this behalf by the person concerned. Unless you are authorized, you cannot sign. Please remember. You need an authorization. All application and communication to the controller should be signed may be signed by the patent agent. Why? Because applicant directly can submit it. But if you are signing, you must have the authorization by the person concerned. What are the restrictions? Only a person registered as a patent agent can do this. If there is a partnership, a firm can tell that a firm can say that they are patent agent, and they can say that only if all the partners of that firm are patent agent. No one else can say that they are patent agent. A company or any body corporate shall not practice or describe itself or hold itself as patent agent or permit itself to be described or held out. Any company cannot claim that they are patent agent, please, or they are practicing it as a patent agent. If that is the case, they are in violation of patent act. Now comes power of controller to refuse to deal with certain agents. If your name has been removed and not restored to the register, power controller will not recognize you. If you have been convicted of an offense under section 123, that is, you have been practicing without qualifying or without being registered as a patent agent, then you are out. Then comes any person not being registered as a patent agent, any person not being registered as a patent agent, okay, is engaged wholly or mainly in acting as a revenue purpose in the name benefit. Simple. Same thing. Someone you are acting as a patent agent while you are not entitled. Okay. For the person for the person of, who has employed you, you are still working for them as a patent agent. No, you cannot do that. Any company or firm, if any person whom any company or firm will not be considered as they can refuse to recognize as any person if that person is director or manager of that company, then they will not recognize you as an agent. Any person who neither resides nor has a place of business in India will also be understood as no. You should reside in the and you should reside or have a place of business in India. Then only you can be a patent agent. Otherwise, controller can refuse to recognize you as a patent agent. Power of controller to remove the name of agents. So controller can remove if there has been misrepresentation or suppression of material facts. If you have been convicted, if patent agent has been, if the person has been convicted of any offense and sentenced to a term of imprisonment or guilty of misconduct in professional capacity, or he says that, then comes the reasonable, before deciding that, before reviewing, you will give the reasonable possibility of being harmed. How you will, how the name of a patent agent is removed, that first on the request of that patent agent or on the death of that patent agent or 130. So when the controller has removed the name of the person under subsection 1 of the 130, this is one, or you have defaulted in the fee. If you are not paying a fee by and defaulted for 3 months, you are out. If he ceases to be a citizen of India, yes, out. Then comes decision to removal of the name of the person from the register of patent shall be published and communicated to the person concerned. It can be restored if restoration can be made by controller on application made in Form 20 within 2 months. If within 2 months you have made in Form 23, you have asked for the restoration of the name, your name will be restored. Restoration of name to the register shall be published on official website and communicated to the person concerned. If the name of a person is intended to register patent, his name shall be continued therein for a period of 1 year from the date on which his last annual fee became. Okay. Once it has been restored, 1 year at least, same thing, because annual fee is paid in the advance. So you will continue for 1 year. Who can also act as agent? Applicant can draft, appear and act before controller, and only in hearing, please remember, only in hearing, advocate on behalf of a party can take part in the proceeding. These are the 2 places where without patent agent, 2 people can work. Restrictive condition commercial contract, I will discuss it tomorrow because it's getting late. So restrictive condition commercial contract, compulsory licensing and government use, and any other topic which has been left will be completed tomorrow.